All right, are you Amber Nicole Doctor appearing there from the jail?
Yes, sir.
All right, this case number 23 CR 65, State of Ohio versus Amber Nicole Doctor. This is a sentencing being conducted by Zoom. This doctor's attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. And Mr. Kirk, do you and your client both agree to this matter being conducted by Zoom rather than in-person hearing in the courtroom?
Yes.
All right.
Yes, Your Honor.
You're all right with that, Ms. Doctor?
Yes.
All right, defendants entered a plea of guilty to count 1, aggravated trafficking in a fentanyl-related compound, 4th-degree felony. Count 3, aggravated trafficking in a fentanyl-related compound, a 3rd-degree felony. The court referred the matter for a pre-sentence report. I've received the report and reviewed the same of each of the attorneys. Had an opportunity to review a summary.
Your Honor.
I have, Your Honor.
All right. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor. There is restitution to the task force in this case, $650 joint and several with co-defendant Jeremy Wilson. That's all, Your Honor. Thank you.
Mr. Kirk?
Thank you, Your Honor. Would ask the court to follow the plea agreement. My understanding is that as we sit here, would be her first felony conviction. She does have a couple, as noted in the PSI summary, that are pending. However, this would be the first. She was essentially, it does not excuse her behavior, but essentially the driver for a couple of drug transactions where Mr. Wilson sold the alleged substances, and she was driving him around. She has owned up to her involvement and has admitted that she needs help, and has been working with the probation department to get into treatment. They do have a bed for her at the counseling center, available as soon as July 7th, as long as the other courts will allow her to participate. So would ask the court to follow the plea agreement.
And when is she set for sentencing in the other cases, or have they been disposed of yet?
I don't believe they've been disposed of yet because she's been over here.
Are there holders at the jail on her?
My understanding is, my understanding is there may be one either out of Clinton or Fayette or both.
Have you had any contact with any of the attorneys in those cases to know what, I mean, are they still pending? Has there been a plea, or what's going on?
I don't think there's been any plea. I think they're just pending right now. I'm not sure who her attorneys are in those situations, or if she has attorneys appointed yet.
Well, so she's not going to go to a bed unless somebody contacts those attorneys and gets them to file a motion with the court.
I know Mrs. Sturgill did speak with at least one of the counties, and I believe was working with them to try to make that happen.
Well, that's not Ms. Sturgill's job. That's a defense attorney's job. The probation department doesn't contact other judges and make arrangements with them. That's an ex parte communications improper. So
I don't think she contacted another judge. I'm not saying
okay,
that.
what I'm saying is we can't put this over on our probation department. You know, it's on the judge, it's on the attorneys in those other counties to do something about it. And what I'm saying is right now, she's not going to go to treatment because she's got holders on her.
Your Honor?
Yes.
Yes, I go back to court on Fayette County on July 10th for sentencing, and they said that they would do whatever you guys do.
Who said that?
Fayette County,
Yeah.
where my other indictments are out of.
Is that both out of that county?
Yeah.
Okay, I may have misspoke when I said Clinton, and I thought it was Clinton. So
I have a misdemeanor charge in Clinton County.
There's also an indictment in Clinton County from May 5th.
Okay.
You don't have that yet?
No.
Be careful with him in that corner. I mean, in the window, because that.
Ms. Barger, you want to mute yourself there? You're coming through.
Oh, I'm sorry.
Yeah. Yeah, I mean, with these other two indictments pending, if I put her on probation, then she's going to go to those counties. And then if they put her on probation, unless she goes directly from there, she'll be back. I mean, she's going to be out of jail. We've had this problem before, where we release somebody to go to a different county, then they got out, and then they never end up going to treatment, or there was a big delay, and they ended up on a PV. So I'm kind of reluctant to do anything at this point until we know, particularly, we need something from, we can't make Clinton County come and get her. They probably won't. Well, I'm going to go ahead and proceed. It's the order of the court, Miss Doctor, that you be placed on 3 years of community control under the following conditions. You obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed. You must be honest in all statements that you give to the probation department. You must keep your supervising officer informed of your residence, place, of employment at all times. May not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior permission. You're not permitted, because of your conviction, to possess, purchase, own, use, or have under your control a firearm, ammunition, dangerous ordnance, or weapon of any other type. To do so would be a violation of both federal and state law, subject you to prosecution. It also is a condition that you not have those during your community control. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance has an effect similar to a controlled substance or drug of abuse, nor any instrument, device, or thing that may be used to administer those, prepare them for administration, unless you have a lawful prescription, a copy of which must be provided within 24 hours of receipt. You're to submit to drug testing when and as directed. You're not to purchase, possess, use, or have under your control any alcoholic beverage or be present in a place where they're sold or being consumed. You're not associated with any of the co-defendants in this case, or any other person has a record, a member of a gang, or any other person or group who has in the past or could in the future influence you to commit a violation of these conditions, unless approved in writing by your supervising officer. You may not, after the date of this order, marry or establish cohabitation, a common law marriage type relationship with another without written permission. You must report any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You're to provide your supervising officer financial information records so your ability to pay any fines, fees, or costs can be reviewed. If the probation department refers you for any evaluation or assessment for any other type of treatment, then you're to submit to that, and if recommended, you're to successfully complete any program. You'll pay the court costs of this action and make payment arrangements to do that. You'll do 400 hours of community service at the rate of 20 hours per week for 20 consecutive weeks, unless you're employed at least 20 hours a week, or you have a documentation that you have a prior disability finding or a medical condition that makes you unable to do that. You're to pay restitution through the victim witness escrow account in monthly payments as determined by probation. You are to successfully complete substance use disorder residential treatment and aftercare.
First.
You, by being placed on community control, are deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property places under your control where you're found at any time of any other officer of the probation department. Now, there'll be no fine, there'll be no driving suspension. You're ordered to pay restitution in the amount of $650 to the Highland County Task Force, joint several with your co-defendant, Jeremy Joseph Wilson, and pay any fees associated with that. In the event you fail to pay your court cost, which is also ordered, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, the court could order you to do community service or give you, while you're still in community control, in addition to what I've already ordered, and that would be credited in an hourly rate set by court for each hour you work until that was paid full. Now, in the event that it's alleged that you have failed to comply with your community control, the probation department will file a written notice with the court. There will be a hearing. You'll be given a copy of the allegation. You'll be entitled to have an attorney. If the outcome of the hearing is that you failed to comply, then at that time you can be sentenced to a period of between 9 and 54 months and fined $15,000. And if that happens, then upon completion of that prison term, you may be put under post-release control supervision by the Adult Parole Authority for a period of up to 2 years, and if they do, you'll be supervised under the terms they set. If you violate those terms, they can return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. But if you committed a felony, then in addition to whatever sentence the judge in the new case can impose upon you, the judge is also authorized to sentence you for committing that violation while under post-release control, in this case to an additional period of a year, or whatever time's left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively sentenced in a new case. Now, you're going to be ordered to be released forthwith to Fayette County or, well, I don't know who has a priority on you, but you're be released. Now, once you get done with those counties, if they send you directly to a treatment facility, then you'll, that'll be the treatment plan that I've ordered. Although STAR is not going to be sufficient. If they send you to STAR, you're still going to be required to do a substance use disorder residential treatment and aftercare, because STAR is not primarily substance use disorder. It's a more comprehensive approach. It does include components of drug treatment, but it's not exclusively that. Now, if you get released before going to treatment, then you need to report to the probation department as soon as you're released from the other counties. If they release you without you going directly to a treatment facility. And in that time, Ms. Sturgill will make arrangements to get a placement for you if you haven't in the other counties. But you need to make sure that your attorney in the other counties talks to Ms. Sturgill as well to keep her informed and our probation department informed of what's going on. Because if they release you and say, well, you're going to go to court when Highland County comes and you don't report to probation, there's going to be a warrant out for you. And if that happens, I'm most likely inclined to revoke you and send you to prison because of this mess that we have here with your multi-county jurisdiction. And that'll be on you. So you need to do what I'm telling you. So if you get out of jail, you contact the probation department. You contact Mr. Unless you go directly there. And again, even if you do, you need to reach out and contact, have your attorneys up there notify that here so we know what's going on. When I say we, our probation department. All right. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. Thank you. All right. Your client's over here, Mr. Kirk. All right. All right, case number 23 CR 46, State of Ohio versus Daniel Butcher. Are you Daniel Butcher?
Yes, sir.
All right, this is a sentencing being conducted by Zoom. The defendant's entered a plea of guilty to possession of drugs, a 5th-degree felony. Mr. Butcher's attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office is Assistant Prosecutor King. Defendant, number one, Ms. Barger, do you and your client both agree to this matter being conducted remotely by Zoom rather than an in-person appearance in the courtroom?
Yes, Your Honor.
All right, is that all right with you, Mr. Butcher?
Yes, sir.
All right. Now, the court ordered a pre-sentence investigation. I've reviewed that, and have each of the attorneys had an opportunity to review a summary?
Hey, guys, Your Honor.
Yes, Your Honor.
All right. Ms. Sturgill, I have a letter stating that there was a bed available for him on June the 23rd, which was dated that same day, and I didn't sign it. Is there a bed available for him now? Because I didn't see anything in the PSI report.
Yes, sir. I actually filed a correction on Friday that corrected that bed date to July 7th. I asked them to send it up to you.
Well,
I did file that for myself.
It did make it up, so, okay, July the 7th?
Yes,
Okay.
sir.
All right. All right, anything from the state?
Only was contained in the plea agreement, Your Honor.
All right, Ms. Barger?
Just what is contained in the plea agreement, Your Honor.
All right, Mr. Butcher, anything you would like to say?
No, sir.
Now, you've made an application for the drug court, and you know, that is something that's voluntary. The court doesn't require people to go into drug court because it's based upon their determination that they want help, and they want to be sober, and if they stay sober, they're not going to commit further crime. Is this something that you still want to do?
Yes, sir.
All right. And the court will admit you into the drug court docket. It's the order of the court to be placed on 3 years of community control supervision under the terms that are set forth in the drug court program description that you've been provided and have signed. The court will go over some of those. First of all, it's going to be for a period of 3 years. Now, you're to comply with all those conditions. You're also comply with bail laws of all jurisdictions. Conduct yourself in law-abiding manner at all times. Report when and as directed. Be truthful in all statements you make in probation regarding your supervision. Just keep them informed of residence and place of employment at all times. May not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate or attempt to communicate with anyone as an inmate in these facilities without prior permission. May not purchase, possess, own, use, or have under control any firearm, ammunition, or dangerous ordnance. To do so be a new felony under both federal and state law, subject to new prosecution. You're not allowed to have any of those or any other weapons of any other type while you're on community control. You're not permitted to purchase, possess, use, or have under control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance, drug of abuse that has any effect similar to a drug of abuse or controlled substance. Nor may you have any device, instrument, or thing that may be used to administer those or prepare their administration unless you have a lawful prescription for both the devices as well as the substance. You must provide a copy of that within 24 hours of receipt when you do get one. You must submit to drug testing when and as requested by the probation department or the treatment team. You're not permitted to purchase, possess, use, or have under control any kind of alcoholic beverage, nor may be present in places where they're sold, being consumed, even if it's otherwise lawful. You're not to associate with anyone as a co-defendant in this case, nor any other person who has a criminal record, member of a gang, or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions unless that's approved in writing by your supervising officer. That apply to any family members other than those that were residing with you immediately prior to the commission of the offense. You may not, after the date of this order, marry or establish cohabitation, a common law marriage type relationship with another without written permission. You must report any charge of violating the law or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You must provide financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department or the treatment team for further assessments or evaluation for any kind of programming, you'll submit to that. If there's any recommendation for programming, you're to roll in and successfully complete that, pay the court cost. You remain in the jail until conveyed to what facility was that, Ms. Sturgill?
The counseling center.
All right, thank you. To TCC. You're to comply with all treatment team recommendations, and that will include completing the residential treatment and aftercare. Now, by being placed on community control rather than being sentenced to prison, you're deemed to consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control where you're found at any time, and you'll be required to sign a acknowledgement of that in writing with the probation department. There will be no fine nor suspension of your driving privileges. You're also ordered to pay the court cost, and that's a substantive order, and that'll also make payment arrangements to do that as a condition. If you fail to make payments or pay the court cost, then the court could order you to do community service and give you credit for each hour you worked at an hourly rate set by the court. Each hour you worked, reduce your judgment for that amount until paid in full. Now, in the event that you are that's alleged that you failed to violate or comply with these conditions, written notice that will be filed with the court. You'll be given a copy. There will be a hearing. and you'll be entitled to have an attorney. If the outcome of that is that you have failed to comply, the court will terminate you from the drug court docket, return you to the active docket, and you will be sentenced to prison for a period between 6 and 12 months in order to pay a fine of $2,500. If that happens upon your completion, it is possible that the Adult Parole Authority will put you under post-release control supervision for a period of up to 2 years. If they do, be supervised in the term set by the probation department or by the parole authority. And in the event you violate any of those, they can return you to prison, make you serve an additional period of up to half of the prison term for one or more violations. However, if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you to an additional term of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, she'll be held in jail until you're conveyed. And what was that bed date again, Miss Sturgill?
On Friday, sir.
Friday the 7th, all right.
July 7th, yes.
All right, thank you. All right.
It's a staff in person. I'm on this.
All right, are you Joshua Shane Hammond appearing from the jail?
Yes, sir.
All right, we have two cases here involving Mr. Hammond. Case number 23 CR 59, which is convicted of aggravated possession of methamphetamine, and case number 23 CR 123, convicted also of aggravated possession of methamphetamine, both fifth-degree felonies. The court ordered a pre-sentence report, and I've received that and reviewed the same. Mr. Hammond's attorney is Sarah Barger. The state is represented by Adam King. This hearing is being conducted by Zoom. All the attorneys are appearing from their offices, and Mr. Hammond is appearing from the jail. And Ms. Barger, you and your client both waive his physical presence in the courtroom and agree to this matter being conducted by Zoom.
Yes, Your Honor.
And you're all right with that, Mr. Hammond?
Yes, sir.
All right. The court did review the pre-sentence report, and of each of the attorneys had an opportunity to review that as well.
Yes.
Your Honor.
All right. Mr. King, anything on behalf of the state?
Only was contained in the plea agreement in each case, Your Honor.
Ms. Barger?
This is what is contained in the plea agreement, Your Honor.
Anything you'd like to say, Mr. Hammond?
Not right now.
All right, now, Mr. Hammond, you've made application for the drug court, and believe you met with Ms. Sturgill, went over that, and signed the application. Is that correct?
Yes, sir.
Now, under the law, the judge does not order people into drug court. They have to apply to be accepted into the program. You've made that application. You do meet the criteria. The question, though, is if you still want to do that, because the drug court is more intensive than regular probation. Regular probation or community control is designed to help the person stay out of jail and hopefully help them along the way with their issues. But the focus is, preventing them from going to prison. The approach the drug court takes is we focus upon the person's situation, their treatment, their overall life skills, and with a broader approach. And it's much more intensive, it's much more difficult, but if you successfully complete that, then the chances of you committing a new crime are extremely reduced. And so my question to you is this still what you want to do? I'm sorry.
Yeah.
Pardon me?
Yes.
Okay. All right. Well, then it's the order of the court that you be accepted into the drug court docket in each case, and it's ordered that you be put on community control under the following conditions in each case. First, you're to obey all laws. Well, first of all, it'll be for a period of 3 years. You'll be required to obey all of the conditions set forth in the program description that you've been provided in your application, and you're to comply with all of those. Now, I'm going to highlight some of those. You specifically must obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. Be truthful in all statements you make to the probation department regarding your supervision. You must keep them informed of your residence and place of employment at all times. May not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you do, you must have that pass with you. May not enter upon, once you're released from custody, enter upon the grounds of any correctional facility of any jurisdiction, nor may you communicate with or attempt to communicate with anyone who is an inmate in any of those facilities without prior written permission. Now, because of your convictions, you're prohibited under both federal and state law from possessing, purchasing, owning, or using any firearm, ammunition, or dangerous ordnance. To do so would be a new felony, subject to you to prosecution under both state and federal law. You're also not permitted to have any of those or any other weapons while you're on community control. You're not to purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance, drug abuse that affects some of the controlled substances, drugs of abuse, or any device or thing that may be used to administer drugs or prepare their administration, except those for which have a lawful prescription, copy of which must be provided to the supervising officer within 24 hours of receipt. You're not permitted to obtain a medical marijuana card. You're to submit to drug testing when and as requested by probation or treatment team. You're not permitted to purchase, possess, use, have under your control any kind of alcoholic beverage or be present in any places where those are sold or being consumed, even as otherwise lawful. You're not permitted to associate with anyone who's a co-defendant in this case or any other person who has in the past or could in the future influence you to commit a criminal violation or violate these conditions unless that's approved in writing by your supervising officer. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship without prior permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. You're to, if you're referred by either the treatment team or the probation department for an evaluation of any further programming, you're to enroll in and or you're to submit to that. And if there's a recommendation of programming, then you are to enroll in and successfully complete that. And you'll remain in the county jail until conveyed to, is that TCC, I think? Yeah, TCC on July the 7th. Now, you're to comply with all recommendations of your treatment plan from your treatment team. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any other property place where you're found that's under your control any time by any officer of the probation department. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will file a written notice that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, at that time the court can terminate you from the drug court. And in case number 20, in each of these cases, sentence you to 6 to 12 months in prison consecutively for a total of 24 months and fine you $2,500 in each case. If that occurs upon completion of the prison term, then it is possible that the adult parole authority may put you under post-release control supervision for a period of up to 2 years. And if they do, then you will be supervised by a parole officer in the terms they set. And if they determine that you have failed to comply, then they can return you to prison, like I said, to serve an additional period of up to half of that prison term. However, if you are charged and convicted of a new felony, then in that case, the judge in that case could sentence you to an additional period for committing that offense under post-release control, in this case, of 1 year or whatever time's left on the post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. All right. Is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. Thank you. All right. That's the complete jail docket. All right, this is case number 23 CR 57, 23 CR 96, both styles, State of Ohio versus Daniel David Hatfield. Are you Daniel David Hatfield appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right. Mr. Hatfield's attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office is Assistant Prosecuting Attorney King. Ms. Barger, you and your client both agree that this sentencing can be conducted by Zoom rather than in person?
Yes, Your Honor.
And you're all right with that, Mr. Hatfield?
Yes, Your Honor.
All right. In case number 23 CR 57, the defendant pled guilty to 3 counts of aggravated possession of methamphetamine, a 5th-degree felony. And in case number 23 CR 96, he pled guilty to tampering with evidence, a 3rd-degree felony. The court did order a pre-sentence report. I have reviewed that, and have each of the attorneys received or had the opportunity to receive a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Nothing from the state, Your Honor.
All right, Ms. Barger?
Thank you, Your Honor. I've had extensive conversations with Mr. Hatfield throughout the life of this case. He, in the beginning, was hesitant towards drug court and towards treatment, and I will say he still is not interested in drug court, but his attitude towards treatment has completely changed. If you review Mr. Hatfield's history, he seems to struggle a lot with his drug use. He can go long periods of being sober and then relapse. Unfortunately, that's what happened last year. He had a relapse, and a lot of these crimes resulted from his relapse. He is requesting that the court admit him into a treatment program and that he be permitted to get back into recovery and get sober again.
All right, Mr. Hatfield, anything you'd like to say?
So just I apologize for my behavior and all that. Wasting time.
All right. Well, Mr. Hatfield, I think the thought was that perhaps you might show some interest in the drug court, but you didn't. And I'll give you credit for that, because I think you're only interested in staying out of prison. You're not really interested in getting and staying clean, because your history shows that. I was looking here that you were admitted into the use program in December and left on February the 23rd without successfully completing that. You were assessed for substance use disorder on February the 17th, 22, the year before, and rejected all treatment recommendations. And so, it seems pretty clear that you have had the opportunity to get treatment, and you've have failed to do so. And the only reason that treatment's being talked about today is because you're facing a jail term or prison term, and that's where we are. And I don't see you have any real interest other than staying out of jail. And so, with regard to case number 23 CR 57, it's ordered that you be sentenced to a term of 6 months on each count to be served consecutively to each other for a total of 18 months. Case number 23 CR 96, you're sentenced to a term of 9 months, and that's ordered to be served consecutively to the sentence in 23 CR 57. So that'll be a total of 27 months. And according to the sheriff, there's no jail time credit because all the time that you've been held in jail has been applied to some misdemeanor cases in county court for a probation violation there. Now, upon completion of your prison term, it is possible that the Adult Parole Authority will place you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised on the terms they set, and if they determine that you have failed to comply, then they can return you to prison even though you serve the entire term set by the court for an additional period of 1 year or whatever time's left on that period of post-release control, whichever is greater. If that occurs, then it must be served consecutively as sentence in a new case. You're also ordered to pay the court costs, which judge will grant executioner's order. If you fail to pay those, then those can be collected by the clerk through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, then you could do community service in this county and be given credit for each hour you work and an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
Just the reason for consecutive sentences, Your Honor.
Yes. Well, these were a series of courses of conduct. All 3 counts in the 57 case were committed on separate dates, as was the tampering in the second case. And then, furthermore, the defendant's history of criminal conduct is such one that it's necessary to protect the public. And the court further finds that one single sentence will not accurately reflect the seriousness of the defendant's behavior, is consistently involving law enforcement having to intervene in his conduct, and that the sentence that's been imposed, which is minimum sentence in all cases, is not disproportionate to the harm caused. All right, thank you. You're made back to custody. All right, Mr. King, we're ready for Mr. Brockman and Mr. Creech in court.
I'll be over, Your Honor.
Thank you. All right, this is case number 23 CR 52, State of Ohio versus Tommy Lee Brockman, appearing for the state's Assistant Prosecutor King, appearing for the defendant's Attorney Dennis Kirk. You're Tommy Lee Brockman?
Yes, sir.
All right, the defendant was convicted by a plea of guilty of failure to comply with war signal police officer, a third-degree felony. The matter was referred to the probation department for a pre-sentence report, which I have reviewed. Have each of the attorneys received a summary?
State has, Your Honor.
I have, Your Honor.
All right. Mr. King, anything on behalf of the state?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. I would note that this will make the defendant's 4th felony conviction. It appears he has 3 prior felony convictions out of the state of Colorado. And looking at the specifics of this case, this involves a pursuit that started in the city limits of Hillsborough. The defendant proceeded through several different streets within the city. The chase ultimately ended in the Rocky Fork area. During the pursuit, the defendant reached speeds of nearly 100 miles per hour. When he finally did stop the vehicle, he exited on foot, attempted to flee, where he was then arrested. I would note, in looking at this defendant's criminal history, he displays a pattern of really just disregarding law enforcement, resisting arrest, escape, obstructing a peace officer, now convicted of failure to comply, which this offense, scratch that, Your Honor. But based upon all that and the defendant's history, the state feels he's not amenable to community control and would ask that he be sentenced to a term of incarceration. Thank you.
Mr. Kirk?
Thank you, Your Honor. Obviously, it's a serious situation, and luckily no one was hurt.
Usually we have something like a substance abuse problem or something driving it. In this case, it appears mental health was a factor. It does not appear there was any intoxication or illegal substances involved. My client has gone out to the Recovery Council, formerly Family Recovery, and been assessed and is now in treatment for bipolar, and they are looking into medications. He has owned up to this. And I believe is going to apologize to the court. He's told me that he's very sorry for what happened. I think fight or flight kicked in, and he did a very bad thing and did the wrong thing and took off trying to get home, because that's Rocky Fork Lake area is where he lives. So obviously did not respond appropriately and has owned up to that. He did bond out during this case, has made all court appearances since bonding out, has remained in constant contact with my office, has remained in contact with the probation department, is compliant with pretrial supervision. He's also compliant with his mental health treatment, as far as I can tell, and would ask the court in this case to grant community control, as I believe that would not demean the seriousness of this. Thank you.
Brockman, you have anything you'd like to say?
Yes, I did make a stupid decision. I'm sorry for what I did, and there was no reason for me to do what I did, and it was a dumb mistake.
Dan. Yeah, John. All right. Well, Mr. Brockman, this is one of the more serious fleeing, what we call fleeing and eluding in the old days. Failure to comply with the order signal of a police officer. The speeds at which you ran. And not to see there was damage to the vehicle. It ended up the tire was off on one of them, and it was just run on the rim. Mirror was broken, and the speeds and the length of the pursuit was such that it caused a risk of real serious harm to other people. And then you tried to run after the vehicle was stopped, and he struck the patrol vehicle at least twice during the pursuit in the attempt to box you in and get you to stop, and there was damage there. And then after getting out of the vehicle, you actively resisted and failed to cooperate. So, there's no question. I don't doubt that you have emotional or mental health issues, but this kind of conduct just can't be tolerated. And so. Taking into consideration that this is your first conviction for a number of years, although you do have previous convictions out of Jefferson County, Colorado for menacing, possession of marijuana, and attempted escape. Those were back in 2007, but you did most recently have in Colorado obstructing law enforcement in 2011. So it's a position of the court that this kind of conduct is such that for the protection of the public and as a hopeful deterrent to others, that person has to be held accountable. So it is ordered of court that you be sentenced to a term of 9 months at the Correction Reception Center in Orion, Ohio, and you'll be given credit for 44 days while you're in jail. Now, upon completion of that prison term, the Adult Parole Authority will place you under post-release control supervision for a period of, I have to find that now. I did not earlier. At least 1 year and up to a maximum of 3. You'll be supervised on the terms they set by a parole officer. If during that period of time you fail to comply with those conditions, they can return you to prison and make you serve an additional period of up to half of your prison term of 4.5 months for one or more violations. But if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. It's also ordered that your driver's license be suspended for the minimum mandatory period of 3 years. Beginning today. There will be no fine imposed. You're also ordered to pay the court costs or the judgment granted and execution order. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court can permit you to do community service once you've completed your prison term, not while you're in prison. It must be done in this county, and you'll be given credit for each hour you worked in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. All right, you're remanded to custody. Is there anything further from counsel?
No, Your Honor.
No, Your Honor.
Thank you. All right, case number 21 CR 68 Stable High versus Stanley Creech. Present for the state's Assistant Prosecutor King. Present for the defendant, Attorney Dennis Kirk. You are Stanley Creech.
Yes, sir.
All right, the defendant is charged with aggravated possession of methamphetamine, a fifth-degree felony. I believe this matter is set for an intervention in lieu of conviction plea. Now, we have that plea form?
Yes, my approach, Your Honor.
You may. Now, I did receive the pre-hearing report, and it noted that Mr. Creech assessed at Claremont Recovery in Batavia for substance abuse issues, and that was recommended that he begin group and individual counseling. It says he completed an individual counseling session on 5/18 and a group session on 5/23. So are you still attending sessions?
Yes, sir.
All right, and have you been providing that information to the probation?
Yeah, they should have sent my progress report to my probation officer either last week or the week before, but I go again tomorrow.
Okay, how often are you going?
Twice a week.
Okay. All right. You can go ahead and go, Lieutenant Brown, thanks. All right, Mr. Creech, you're charged with aggravated possession of methamphetamine, which is a fifth-degree felony. Now, under Ohio law, when a person enters a plea of guilty and is found guilty, normally the next step in the case is a sentencing. And that can be community control or probation, it can be a fine, it can be a jail term or prison term, or any or suspension of driving privileges, or any combination of those possibilities. Once a sentencing entry is filed, then that person has a felony record. But there is a provision under Ohio law which you qualify for, and which is proposed that we do in this case, which allows you to plead guilty but not be found guilty. And what happens is, instead of finding you guilty, the court stays the proceeding, which means it's just stopped, pending a report from probation department as to your progress. Now, during that period of time, you're required to complete your treatment plan with your certified treatment provider. And you will, again, you'll have to have them you have to sign the release of information so they can get your progress reports. One of those conditions also is that you not consume alcohol or any drugs other than those for which you have a valid legal prescription for a period of at least a year. Now, there are also some terms of supervision because you'll be supervised by probation. However, those conditions are not nearly as extensive nor as strict as those for a person who has been convicted. I know you've been in court and heard some of those conditions in other cases. It won't be the same here because the purpose is to allow you to complete your treatment plan. Now, if you complete the treatment plan successfully and you comply with the conditions of the supervision for this program by probation, then upon receipt of that information, the court dismisses the case against you because even though there will be a plea of guilty in the file, there will be no finding of guilty. And so until you've actually been sentenced, you're not convicted. And you can still say, no, I don't have a conviction, but I have it. It's pending, but it's not a conviction. Once you complete the program successfully, then the court dismisses the charge. And even though you pled guilty, there's no conviction. And then the court will set the matter for a sealing hearing. And unless something happens between that time and the hearing, the court will generally seal the record, particularly in drug offenses. And that means then it's no longer on the public record, and no one will be able to see it or hear it. And you'll be able to answer truthfully that you do not have a felony conviction, nor do you have a felony pending. So that's the big advantage to you. Now, the disadvantage is this. You don't get to try the program and hope it works out. And then if it doesn't, come back and say, okay, let's have a trial now, because you're pleading guilty. And so that's why we have to go through all of the rights that I'm about to explain to you. And if probation department notifies the court in writing that you have failed to comply with either your treatment program or with the conditions of supervision or both, then they'll give you a copy of that. There will be a hearing, and you'll be represented by an attorney at that hearing. If you don't have the funds to hire one, the court appoints one for you. And if the outcome of that hearing is that you failed to comply, then at that time the court finds you guilty and then sets a matter for sentencing. Now, at that time, it could be, again, community control, regular community control for up to 5 years under the more comprehensive and stricter provisions that I've mentioned. Or it could be a prison term of 6 to 12 months. It could be a fine of $2,500. Or it could be a license suspension of 6 months to 5 years, or again, any combination of those. If that should happen, then upon completion of the prison term, the law also provides that the Adult Parole Authority could put you under post-release control supervision after that for a period of up to 2 years. And if you fail to comply with those conditions, then they could return you to prison, make you serve up to half of your prison term for all violations, or in the event that you were convicted of a felony while under post-release control, then the judge in that new case could sentence you to a period of a year, whatever time is left on your post-release control, whichever is greater, which you have to run consecutively to the sentence in that new case. Now, you understand all of that?
Yes, sir.
All right, now, the charge alleges that on or about October 19, 2020, in Highland County, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Revised Code, a fifth-degree felony, which carries, again, the possible penalty of 6 to 12 months, fine of $2,500, and license suspension 6 months to 5 years. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand that the sentence for that?
Yes, sir.
All right. And you're not facing any other charges and felony charges anywhere else? You're not on probation, community control, or post-release control for a felony?
Not for a felony, no.
Okay. All right. Now, have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you can try to raise in trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Satisfied with his advice and competence?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Other than being promised to be put into the intervention in lieu of conviction program, has anyone promised you anything to get you to enter this plea today?
No, sir.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
Are you licensed by any state agency or board to do something like if you were a barber or a nursing assistant or something like that? Or the state issues a license?
Like my ISA and like the certification for barbers, that stuff doesn't matter. It's not that.
Probably not. Is that through a government agency?
No.
Then no.
No, sir.
Okay. Now, you have certain constitutional rights you must understand before I can accept your plea, as I explained earlier. And first of all, you have a right to have counsel. Mr. Kirk was appointed to represent you. Now, that wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide.
Your Honor, I was hired.
Oh, I'm sorry, you were retained. That's right. All right. Well, in the event that you weren't able to pay Mr. Kirk, the court would appoint an attorney for you. So you're not entering into this agreement because of your concern about paying for counsel. Does that have any bearing on your
entering into
decision?
this because you're worried about paying for my services?
No, sir.
Okay. You have a right to have a jury trial on this charge, Mr. Creech, in which 12 people will be selected from a group of citizens who live in Highland County that are summoned for jury duty on their trial date. After they are selected, the evidence will be presented, they'll be instructed on the law by the judge, and then that jury would have to decide by unanimous verdict, we know all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive in writing your right to have a jury trial. In that case, you would have what's called a court or bench trial, which means that instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses against you and to cross-examine through your attorney in open court. What that means is that the witnesses against you have to come into court, testify in front of you, in public, the jury, and anyone else that's here. After the prosecutor's done asking that witness question, each witness questions, I should say, then your attorney can ask questions of each witness, which is called cross-examination, the purpose of which is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's called a subpoena. And that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to testify or to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can, the judge can, it's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you at any time, in any way, by anyone involved in the case. In fact, no one's even allowed to talk about it, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state on every essential element of the offense charge. So, the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally you pled not guilty. If you enter a plea of guilty today, pursuant to this agreement that you've signed, then that plea is the opposite of the not guilty plea. But a guilty plea, originally it denied the allegation and denied you committed any crime and exercised all the rights I just described. A guilty plea will be the opposite of that, as I said, and that means that you will waive and give up all the rights I've explained, except your right to have an attorney, which you always have no matter what you plead. But with that exception, your plea of guilty will waive and give up your right to a jury or court trial, will waive and give up your right to confront witnesses in open court and cross-examine through your attorney, will waive and give up your right to use the power of the court to compel or force witnesses to come to court and testify for you, the same as the state. It'll waive and give up your presumption of innocence, because if you say you're guilty, that's what's used to find you guilty. It'll waive and give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. And the plea of guilty, as I said, waives your right to remain silent, because that's what's used to find you guilty. It also subjects you to being sentenced immediately by the court. In this case, it would be a disposition of intervention in lieu of conviction. Finally, it waives and gives up any right to file an appeal on any alleged violations of your rights that you feel may have occurred up until this point. Now, if you should be sentenced in the future to the maximum or under other certain circumstances, things that occurred after today, you could appeal those. But that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen?
Sorry?
Are you a U.S. citizen?
Yes, sir.
And I didn't ask you at the beginning, but this agreement on page 3 says at the top, I enter this plea voluntarily, and right below that appears to be the signature Stan Creech. Is that your signature?
Yes, sir.
Did you just sign this morning?
No, that was a while ago.
All right, and you still want to do this?
Yes, sir.
All right, and you understood there was an agreement to plead guilty?
Yes, sir.
All right. Now, you have any questions about the intervention in lieu program or what will be required?
No, sir.
You understand it?
Yes, sir.
Any questions about the charge or the possible penalties?
No, sir.
You understand that?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
Any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
All right, is there anything you'd like to speak to your attorney about before we go any further?
I don't think so. No, sir.
Any questions at all that you have about anything we've talked about this morning?
No, sir.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the written plea agreement that we've just gone over?
Yes, sir.
All right. Then as to the charge set forth in the indictment that alleges that on or about October 19, 2020, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Vice Code. Charge of aggravated possession of methamphetamine, fifth-degree felony, carrying a possible prison term between 6 and 12 months, fine of $2,500. How do you plead?
Guilty.
All right, thank you. We see you.
Thank you.
All right, the court finds on this day in open court, defendant was violated of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and ordered filed. Court finds that the defendant's drug usage was a factor which led to the commission of the offense, and that the intervention of conviction process would not demean the seriousness of the offense and would substantially reduce the likelihood of any future criminal activity. He's been accepted into an appropriate certified treatment program, is otherwise eligible for community control, is not a repeat or dangerous offender, and is otherwise eligible under 2951.041 of the Ohio Vice Code. Therefore, the court stays all further proceedings, will make no finding at this time of guilt. He'll be put under community control under the probation department for the period of 2 years under the conditions set by the court for the intervention program. He shall also successfully complete the intervention plan, including a requirement that he abstain from using drugs or alcohol for a period of 1 year, apply all the other conditions that the probation department may require, pay the cost of these proceedings. In the event the defendant successfully completes the intervention plan, obeys all other conditions, the court will thereafter dismiss the proceedings and set the matter for a sealing record. If the defendant does not successfully complete the program, or is alleged he has not, upon written notice of that from the probation department served upon the defendant, the court will conduct a hearing with the defendant being represented by counsel, and upon a finding that he has failed to comply, will revoke the defendant's intervention, find him guilty, and subject him to being sentenced for a period of 6 to 12 months and fine $2,500. All right, that completes the case, so you're no longer under pretrial supervision or any of those conditions. You need to report down to the probation department as soon as you're done here so that they can transfer you over to the intervention officer. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, thank you.
Thank you, sir.
You have the Brockman sentence and entry?
Yes, I do, Your Honor.
This is case number 23 CR 83, State of Ohio versus Sandy Rockmartin. Present for the state is Assistant Prosecuting Attorney King. Present for the defendant is Attorney Dennis Kirk. The defendant is not here. The matter was set today for a hearing on intervention lieu. Mr. Kirk, have any knowledge where your client is?
I do not. I know this was originally set for 1:45. I don't know if she got confused. We've tried this morning to call her, as well as my computer system will send a text, and we have not heard back from her.
Okay.
She was in my office on June 22nd to discuss the case and has been compliant with probation as far as I'm aware, so I'm not sure where she's at today.
Well, I have a report here said that she has an assessment set for July the 10th at Fayette Recovery. She did test positive on the 5th and 22nd of June for meth. Her address is Columbus. So we'll wait until this afternoon and see what happens. And if she doesn't appear this afternoon, I'll give you a little chance to maybe contact probation and see if they can locate her.
Okay.
And find out what's going on. But at this point, we can't do the hearing anyway.
Right.
So she's not going to have to come today unless if you can get a hold of her. But if she doesn't show up before 1:45, I won't call the case till the end of the pre-trials.
Okay.
Then I'm going to issue a warrant for it.
Now, if I get a hold of her, would you like her to still present herself before the court?
No. If you get a hold of her, just call us and we'll get a new date.
Okay.
She's not, but I'm wondering why she's going to Fayette Recovery when she lives in Columbus.
Yeah, I don't know.
She shouldn't be eligible for their services. So I'm a little concerned about whether or not what she's doing.
Yeah.
Yeah.
I did get, I told the bailiff initially Fayette Recovery would not give me any information. Apparently they changed their mind, and here about a few minutes ago we did get a fax that just a very brief letter from Kimberly Brown. She stated in her letter that there is an appointment on the 10th at 3:30.
Okay. All right. So if you get a hold of her, let's get a new date set now while we're here. But like I said, I'm concerned about what's going on here because I'm not quite sure why they would be assessing her if she lives. Maybe she's just staying in Columbus and that's her. Let me look here what the probation department has in the PSI. Yeah, Burnell Drive, Columbus.
That's what she reported to me as well.
So she should be going to a Franklin County program where she lives because Fayette Recovery, which concludes Fayette Recovery, it's kind of like now with FRS being under TRC, and they only treat people in their catchment area. So I'm wondering about that. So, okay. So anyway, let's set this for July 20 at 1 p.m. I tell you what we're going to do is let's don't even have her show up. Continue to call her. If she doesn't show up, I won't issue a warrant. I'm just going to go ahead and do that.
Okay.
But you need to let her know that if she doesn't show up then, there will be a warrant.
And then 1 p.m. on
1 p.m. on the 20th. Yep.
Okay. Thank you, Your Honor.
All right. Now you can go ahead and go. I got to get this. All right, this is case number 23 CR 81, State of Ohio versus Robert Taylor. This is a pre-trial being conducted by Zoom, and you are Robert Keith Taylor, appearing there from the jail.
Yes, sir.
All right. The defendant's attorney is Catherine Hapner, appearing from her office. Appearing from the prosecutor's office is prosecuting attorney Collins. The defendant is charged with 3 counts of rape, first-degree felonies. This is the final pre-trial. I believe trial is set for July 24th. All right, it looks like the state complied with bill particulars and the discovery. I don't see a defense compliance. Did you file your compliance yet, Ms. Hapner?
I have not, Your Honor. I've met with my client. I'm waiting to get a couple of names and addresses from his wife for compliance.
Okay. Well, we're just about, 19 days from discovery.
Well,
Mr. Taylor, your discovery was due by today, so you need to tell your wife to get that information to Ms. Hapner ASAP. I'm going to give you until Monday to provide that information, and that would be July the 10th.
What does he mean by compliance?
Now, Ms. Hapner, are there any, I don't see any pretrial motions. You haven't filed any, have you?
I have not, although I did mention the first pretrial that the trial date that is selected, I'm not available. As it appears we will be going to trial, I will be filing a motion to continue.
All right. And is that due to a previously scheduled case or something else?
It is. I've got about, at this point in time, 1, 2, 3, 5 hearings in county court, plus a hearing in juvenile court that day. They've been scheduled prior to this.
All right. And has your client signed a time waiver yet?
I don't believe he has, but I'll go out to the jail and get that from him.
All right.
I did discuss the continuance with him, and he was fine with that.
All right. Well, we'll need to set that for hearing because we'll need to notify the victims. So you'll need to file that ASAP so we can get a notice set for the continuance. Unless
I'll get it in this week.
I would ask Ms. Collins, is the victim representative present for today's hearing?
And she is not.
All right. Was she notified of the time and place and purpose of today's hearing?
Yes, they were.
All right. Well, can you get that motion filed by, today's Wednesday, by Friday, Ms. Hapner?
I sure will.
All right. Let's set a hearing date. Tentatively, assuming that you get the motion filed, so the prosecutor can give notice to the victims and consult.
Sure.
And while we're doing it, we might as well do an alternate trial date as well. What's next Tuesday? Let's see. I know Tuesday afternoon I'll have to be out at 3 o'clock, but prior to that, what's going on?
A lot. Because we're pushing it here.
Okay, and Wednesday the trial's off, right?
Yeah, you have morning.
How about Wednesday morning, Ms. Hapner? Are you available then?
Next Wednesday?
Mm-hmm.
For a status hearing?
Well, on the motion to continue.
I'm actually in a jury trial next Wednesday in Fayette County all day.
Okay.
Should we do 1:15?
How about Tuesday afternoon at 1:30? Those are ceiling records.
Yep, that'll work.
All right.
We'll do that.
All right, 1:30, that'll be on a motion to continue. Now, as far as trial date, what do we have in August, Marcia? We're kind of, let's see, the 7th is in one case. All right.
Your Honor, if I may, we'd like to
Pardon me?
maybe set, if I may, we'd like to set this as soon as possible, early in August, because these girls are going to go back to school in August, and this doesn't need to be interfering with their lives in the school.
Let's look in July. End of July.
Oh, we already have one going.
See,
July
when
27th, we have that one going. That's good.
yeah. Mm-hmm.
And that's gonna be 4 weeks of tomorrow.
About,
Wait a minute. We just set that with Ben.
well,
today.
that'll just have to be changed if that's available. How about August the 14th? That's a Monday for trial date.
That's my regular morning in Fayette County.
Well, how about Tuesday the 15th?
Yep, that works.
All right. That's the soonest we have available. So that will be the tentative trial date. All right.
Just one day or
Um,
hold the second?
We'll hold a second. Should be all right.
Okay.
All right. Anything else then we need to discuss at this time?
No,
No,
you're,
Your Honor.
All right, yeah, Mr. Taylor, your attorney's going to come out and talk to you about continuance since she's not available, and because we don't really have any other options, because wouldn't be another attorney available that soon. And, you know, this is a major case for everybody, so you want to make sure she's prepared. So she'll be asking you to sign a time waiver. And like I said, we'll have to have a hearing on that to hear the input of the victims, alleged victims, but you know, right now that would be the tentative date if we do that. All right, anything further?
No, Your Honor.
All right, thank you. Donald Hill next, please.
Okay.
All right, this case number 23 CR 82, State of Ohio versus Donald Lee Hill. Are you Donald Lee Hill appearing there from the jail?
Yes, sir.
All right, Mr. Hill is, this is a final pretrial being conducted by Zoom. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. Mr. Hill is charged with 5 counts of sexual battery. The matter set for trial of January the 24th. Now, July 24th. I see the discovery's been provided. There are no pretrial motions, are there?
Not from the state.
All right, I do see a motion for continuance from Mr. Armentrout. Now, let me ask Ms. Collins, is there a representative of the alleged victim or victims present for this hearing?
And she's actually in our victim witness office.
Okay, all right.
She's not on screen and doesn't want to, like, she just wanted to listen to what was going on.
All right, okay. Well, the Mr. Armentrout has filed a motion for continuance due to a conflict in his schedule as well, so since that representative is present, we'll go ahead and address that matter. And the defendant has executed a time waiver, I believe, for that. Yes. Okay. All right.
If I may, Your Honor, the matter when it was originally scheduled for trial, I had already been scheduled, previously scheduled out of the office when it was set. Just tried, working through the case, hoping we'd get to a resolution. I believe that we will. I went over with my client, and he executed a time waiver. I believe he understands the ramifications of it, and we'd ask the court to consider it.
All right, Ms. Collins.
My understanding is that the victim wants this to be over with, so she does not agree with the continuance.
Okay. Well, again, when we get these cases and they're set on a tight schedule because of speedy trial, we set them, and we set them before the attorneys usually are appointed. So conflicts do occur, and therefore, and it does appear the matter may get resolved. So, well, I should have had her leave the calendar.
Would it be possible for me to, when I'm finished here today, although mine are incarcerated today, Your Honor, could I get with your assignment commissioner immediately following my time here and get that reset?
Oh, we're going to do it right now.
Okay.
I got to see what I have. We have a lot of trials coming up, and this is not a real good time for these, but I know this is a busy time of the year. There's a lot of conflicts that are going on. This was set for the 24th?
Yes.
Yes.
Well, on July 31st, we have the Miller trial, but that's going to go, right?
As far as I know, I haven't heard back from his attorney.
And then the week of the 7th is completely full because of the other case, so August 14.
Well, you just set the last one for the 15th.
Yeah, that's true, we did.
So if this one takes more than a day,
Okay. Well, August.
I don't know if it will or not, but it
Wait
might.
a minute, yes, okay. August the 21st. Armin Trout.
Looking, Judge. I have a couple pre-trials in county court, but I believe I could move those, Your Honor.
Okay. All right, then I'm going to grant the continuance to August the 21st at 8 a.m. And we will set a final pre-trial for August the 2nd at 1 p.m. You available then, Mr. Armitrout?
Yes.
All right. And time will be charged to the defendant pursuant to Revised Code 2945.72H. All right, any other matters discussed on this case?
No, Your Honor.
All right, thank you. Seth Beatty's the next case.
Yes, Your Honor.
Okay, what date did I just set that for, Dan? August 21st? What was the time I just set that trial? She took the file already.
8 a.m.
When was it?
8 a.m.
No, when? What day?
August 21st.
Okay. All right. All right, are you Seth Beatty there at the jail?
Yes, sir, Your Honor.
All right, this is case number 23 CR 90, State of Ohio versus Seth Ryan Beatty. Mr. Beatty is appearing by Zoom from the jail. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. You are Seth Ryan Beatty at the jail, right?
Yes, sir.
All right. Mr. Beatty's charged with 2 counts of pandering and obscenity involving a minor. Today is a final pretrial. I believe this case was set for the 24th of July as well as a previous case. Now, discovery complete on this case?
Yes, Your Honor.
And there have been no pretrial motions other than the motion to continue?
That's correct. There won't be any.
All right. And has there been a written plea offer provided?
Yes,
Yes,
he's
sir.
aware of it.
All right. All right, so in terms, I mean, is this anticipated this case is going to go to trial?
No, I'm satisfied that this will resolve through a plea. If the court probably doesn't like to do it, but I would be fine setting her for the 21st of also, the same day as Mr. Hills, but if you don't want to do that, that's okay. But we've had negotiations, and I believe we will get a resolution.
Well, I can set it if, well, first of all, do we have a representative of the alleged victim present for this hearing?
No, but they were made aware of the hearing and the purpose of the hearing.
Okay.
But I didn't know that he filed a motion to continue. I don't have that in my file. When did you file that?
Just this morning, it looks like.
This morning.
Yeah,
So
today.
I made you aware of it, I think, yesterday maybe, or Monday.
I knew that you had these hearings or that you had a problem with the 24th. I didn't realize that you filed a motion to continue, so I didn't notify the victim that this was going to be for a hearing on a motion to continue.
All right. Well, then we'll need to set this for a hearing on the motion to continue. So let's set it for next Tuesday. Or see, was that Tuesday or Wednesday? We set those previous ones. Let's see. Oh, that was with Ms. Hackner, I think. Mr. Armentrout, are you available on Tuesday the 11th? Well, actually, we set Ms. Hackner then, yeah.
No, Judge.
Pardon me?
I think you might be in the wrong month. You set Ms. Hackner's for the 15th. Oh, okay.
I don't think so. That's a Saturday.
I thought you were talking about a trial day, not the motion to continue.
No, I'm talking about a motion date.
Yeah, the 11th.
I'm going to have to quit talking. I was thinking out loud. How about Wednesday morning, Mr. Armentrout, July the 12th?
I've got an all morning with Judge Greer, Your Honor. The afternoon is open.
Okay, how about, well, I have 1:30 arraignment from Grafton, but those are often unpredictable whether they are even going to be available, let alone on time. How about 1:45?
Next Wednesday? That's fine.
Yes, the 12th. All right, so the motion to continue will be set for Wednesday the 12th at 1:45. And you'll notify the victim, Ms. Collins.
Yes, Your Honor.
Or alleged victim. All right, and then possible alternative trial date, if I do grant the motion, would, let's see, that's going to have to be later in August because we went through all the earlier dates available in the last case. Well, you said you'd be all right setting this the same date? I mean, if you're waiving time, we can do that, but he'd have to understand that it'd be subject to potentially continue it further if the other case goes to trial.
Yeah, and I feel fairly confident it resolves through plea, Your Honor. You never know, but I just...
Okay. Well, we'll go ahead and tentatively set it then for
I think it's safe to say, too, Your Honor, that if Mr. Beatty went to trial, which I doubt, it would not be more than one day. Do you agree with that, Ms. Collins? You got 3 or 4 witnesses, I think.
Yeah, I would agree with that.
what about August the 17th?
We have Mr. Dixon set for that day already.
Yeah, I think there's a motion to continue that one, isn't there?
No,
Yeah, because that's a co-defendant to fist, isn't it?
It is, but Dixon's already been moved to the 17th. If there's a motion to continue.
Okay, that's already the date? Oh, okay, that's the tentative date? Okay. All right. And August the 21st was the one we set for Mr. Armentrout earlier, right?
Yes.
That's on Mr. Hill.
Yeah. Well, we'll set it for then, and if the Hill's one case, one day we may end up doing this the next day or even the following Wednesday, or we could go to the 24th. What's the 24th look like? That's a motion day, but I can work around that.
That's fine. The 24th, did you say, Your Honor?
Yeah. Again, after we hear from the victim, alleged victim, and have the hearing on the motion, but that would be the potential trial date.
Yeah, I could do the 24th.
All right. All right. Well, we'll just plan on that. All right. Now, are there any other matters to be brought up?
No, Your Honor.
Well, and I think you folks are family members. All right. Well, I want to make this statement in your presence to you as well as to Mr. Beatty. I've been getting letters and pictures and whole stuff from you folks, and that's highly improper. You would not want me to be getting, if a victim's family wanted this man strung up from the nearest tree, you wouldn't want me to be getting letters from them and decide based on what they told me in those letters. Same thing, I can't decide something on it. Plus, he's not been convicted yet, so it's highly improper. I didn't read any of it. As soon as I saw it was about Seth Beatty, I gave it to the bailiff. It goes to what I call a jail mail file. I don't read them because it's improper for me to do so. So don't send me any more letters. If you want to communicate through Mr. Armentrout, your son's attorney, or Mr. Beatty's attorney, and then he will decide what's proper to bring to the court. But it has to be also served on the opposing party, the prosecutor. You just can't send letters. I don't know why people think that judges, somebody can write the judge a letter and the judge is going to make a decision. If you just think about it, it violates fundamental fairness. So I know you didn't know that, but I'm explaining that to you. All right. Thank you, Mr. Beatty. Your attorney will be in touch with you. We'll be having a hearing on the motion to continue next week. Thank you.
All right, thank you, Your Honor.
All right, Dwayne Devine would be. All right, are you Dustin Schwalbach appearing there from the jail?
Yes, Your Honor.
All right, this is case number 23 CR 91, State of Ohio versus Dustin Schwalbach, Dustin Jack Schwalbach. Mr. Schwalbach is appearing from the jail. His attorney is William Armentrout, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. Defendant's charged with having a weapon under disability and a forfeiture. This is a final pretrial. We have a trial date on July 27. Looks like the discovery's been completed by the state and the defendant. There are no pretrial motions, are there?
No, Your Honor.
Right, so
if I may, Your Honor.
Go ahead.
Ms. Collins and I came to an agreement this morning, and my client has accepted it. I just need to get revised plea form and set a plea date the next day or two, or at the convenience of the court.
Well, how about tomorrow? Let's see what I got tomorrow. There's no victim, alleged victim in this case, so.
And I have Mr. Sears for a plea at 2 o'clock. If we could do it right after that.
All right, 2:15. All right. Plea for 2/15. Yeah, and you want to do that by Zoom?
That's fine, Your Honor.
All right, 2/15, July the 6th. All right.
Your Honor, can you tell from your calendar if you have the Sears plea, is that Zoom or in person? I don't know.
It doesn't say,
Okay,
so it may be in person.
okay.
Is he? He's not in custody, is he?
No, he's not.
Okay. Unless you, if you can find an email for him to forward him the link, we can do that by Zoom as well.
Okay.
All right. So we'll be talking to you tomorrow, Mr. Schwalbach. Thank you.
All right.
All right. Then the next one in. All right, are you Donald Earl Elliott appearing there from the jail?
Yes, sir.
All right, this is case number 23 CR 114, State of Ohio versus Donald Earl Elliott. Mr. Elliott was indicted along with 2 co-defendants in a multi-count indictment. Looks like he's in counts 1 through 10. His attorney, this hearing being conducted by Zoom, he's appearing from the jail. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. See, the state filed a bill of particulars and the discovery, and don't see yours yet, Mr. Armentrout. That was just filed Monday, so yours is due by the final pretrial. And at this point, do you anticipate any pretrial motions?
No, Your Honor. I've spoken to my client. I have the discovery. I've not gotten a copy to him yet, or he hasn't had a chance to look at the video.
Okay. All right. I see the final pretrial in this one is August 2nd with a trial date of August 31. So, okay. Are there any other matters we need to discuss then at this time?
No, Your Honor.
All right. Your attorney will be in touch with you, Mr. Elliott, and we'll have a pretrial in the second unless something else comes up before then. Thank you.
All right, thank you, Your Honor.
All right. Mr. White. There it is. All right, are you Jamie Weiskup appearing there from the jail?
Yes, sir.
Case number 23 CR 115, State of Ohio versus Jamie A. Weiskup. Mr. Weiskup's been, this is a hearing being conducted by Zoom. He's appearing from the jail. His attorney is Jacob Wagner, who is appearing from his office. Appearing from the prosecutor's office, Prosecutor Collins. Defendant's indicted along with 2 other co-defendants in multi-count indictment. It looks like he's indicted in counts 9 and 10, which is aggravated trafficking and aggravated possession of methamphetamine. So this is a first pretrial, final pretrial set for the 2nd, and trial set for the 28th. See, the state provided discovery and requested discovery. Your discovery, Mr. Wagner, will be due by the final pretrial.
Yes,
Yes, sir.
Now, do you anticipate any pretrial motions?
I do not, sir.
And has there been a written plea offer provided?
Yes,
It has, and relayed and discovery gone over with my client. I feel, if I may, Your Honor, if I could address the court, I feel this will resolve. So you can go over a few more pieces of discovery. Just for the record, to protect myself, I think in the discovery, if I'm correct, Donald McKenzie is mentioned. I did represent him in the past. I've mentioned that to my client. He's still comfortable with me going forward. Is that correct, sir?
Yes, sir.
Different one?
It's not Mr. McKenzie. It's Donna McKenzie. It's a woman.
Oh, okay. I was just, the last name popped out to me.
It's Donald Elliott and Donna McKenzie.
Well, I could have said without even asking that the state was not going to call Donald McKenzie as a witness, so, yeah. All right. All right. Anything else then we need to discuss at this time?
No, sir, Your Honor.
All right. Your attorney will be in touch with you then, Mr. Weisskopf. Thank you.
Thank you, guys. Thank you, Your Honor.
All right. I think that's everybody from the jail, right? Case number 23CR78, State of Ohio versus Joey Ray Dixon Jr. And you're Joey Ray Dixon Jr. appearing there on the screen marked HCPD.
Yes, Your Honor.
All right. This is a pretrial being conducted by Zoom. Mr. Dixon's attorney is Jacob Wagner, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This, I believe, is the final pretrial, is it not?
Yes.
Yeah, okay. So discovery is complete?
If I may address the court, Your Honor?
Yes.
Yes, the state has supplied me with a lot of flash drives, a lot of paperwork. I still owe Ms. Collins discovery. You know, all I'm waiting on, Your Honor, I've met with Joey twice. He always comes to my office when I need him. But he's compiling some records that I may be filing with an alibi notice. And the only reason I haven't filed that is I don't know about the business or his employment records. So as soon as I get those, I'll file them with Ms. Collins, Your Honor.
All right. And I get, we'd already did continue this until August the 17th. Okay. All right. Maybe council knows this, but was there been an amendment to Rule 16?
There has been.
To require a advance notice. What's the deadline on that?
I just looked this up for another case, and I want to say it's 30 days now. The amendment to the rule was in March.
Mm-hmm. Yeah. So you may be out of time on that, Mr. Wagner, but you go ahead and take a look at it. All right. All right. Any...
You wouldn't be out of time yet.
How would I be out of time, Your Honor, if I may?
Because there's a new deadline for alibi notices and rules, criminal procedure.
30 days, July 17th, if I let the state know prior to that, correct? It's set for August 17th.
Oh, I'm sorry. Yeah, that's right. Yeah, I was thinking it was July 27th, but we continued it, didn't we? Okay. Yeah. Then you're all right. Sorry, I didn't want to give you a heart attack. Yeah.
You did for a second there. The only other question I may have, I know we're set for a status next week, and I've discussed this with Ms. Collins. I think, I don't know, I don't want to speak for the state. The intent would be to try these two together. Correct. There's a co-defendant. There's going to be, in my mind, a clear Bruton issue. I don't know about severing these or how the state's position is. I'm open to whatever the state suggests. I know they have a rape trial just 2 days prior to this.
Now, we had the hearing on Fisk's case yet?
No, we haven't had a hearing on the continuance of his case.
Okay.
But they're both set now next week for a continuance hearing.
All right. Okay. Well, in that case, it may be that if we continue this one, we don't need to continue the other one. So we can do it if there's a Bruton issue. So do you think there is a Bruton issue, Ms. Collins?
I think there's, right now there is, yes.
Okay, well, then in that case, we don't need to address the Fisk issue then. You haven't filed, there's been no motion for continuance on that filed, so we'll go ahead and, we won't do anything with that then. So we should be all right if I grant the continuance. Well,
Yes,
at this
sir.
point, you know, if there's a Bruton issue, it's gonna have to be done, so. But we'll wait and, again, we have to wait until we have the hearing to let the representative of the alleged victim express their position.
Yes, sir.
Anything else that we need to discuss on this case?
No.
No, Your Honor.
All right.
Give me a call, Joey.
I will.
Okay.
Thank you, Your Honor. Sorry, Your Honor.
Dwayne Devine, is he there at PD, the 23 CR 112, State of Ohio versus Dwayne Devine Jr. You're Dwayne Devine Jr. appearing there from the HCPD screen.
Yes, sir.
All right, this is a pretrial hearing by Zoom. The defendant is represented by Catherine Hapner, appearing from her office, appearing from the prosecutor's office of Prosecutor Collins. This is a first pretrial. Final pretrial is August 2. Trial date's August 28. Defendant's charged in a 5-count indictment. I see that the state provided discovery and a bill of particulars. You received that, Ms. Hapner?
I have, yes.
All right. Your discovery will be due by the final pretrial, and are you anticipating any pretrial motions?
Not at this time.
All right. Has there been a written plea offer provided?
It has been communicated.
Okay. And have you talked to your client about that yet?
No, Dwayne, I need you to call my office so we can talk about the offer about your case. So you need to do that right away.
Okay.
All right. Any other matters need to be discussed then?
No, Your Honor.
All right. Make sure you get in touch with your attorney tomorrow, Mr. Devine, so you can get an appointment to see her. Thank you.
Yes, sir.
All right. Andrew Johnson. Yeah, well, that's not till 2. Tiffany McKenzie. Is Miss McKenzie there at the probation department? All right. Are you Tiffany McKenzie appearing there from the probation department?
Yes.
All right. This case number 23 CR 113, State of Ohio versus Tiffany Sue McKenzie. Ms. McKenzie's attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office, Prosecutor Annika Collins. Defendant's charged with a co-defendant. She's charged in counts 4 and 5 with trafficking in drugs, 5th degree felony, and possession of drugs, a 1st degree misdemeanor. See that this is the first pretrial, and the final pretrial, I believe, was the 2nd. and the trial date is the 28th, I believe, of August. The defendant has been provided discovery and bill particulars, it looks like, and you've received that, Ms. Barger?
I have, Your Honor. My client is aware that I have it. We were supposed to have a meeting today. Unfortunately, due to unforeseen circumstances, I had to cancel our meeting to reschedule it.
Okay. You anticipate any pretrial motions?
Not at this time.
All right, you have the written plea offer as well?
Yes,
All right. And you have not yet been able to discuss that?
that is correct. She is aware of that I have the offer, but she's not aware of what it is yet.
All right, okay. All right, well, Ms. McKenzie, make sure you keep that appointment so that your attorney can keep us informed of what's going on.
Okay,
All right, thank you.
thank you.
All right, Mr. Argini, do you have anybody else that's set for 2 o'clock that might be there early? CR 85. Okay. All right, this is case number 23 CR 85, State of Ohio versus.
Why is the volume not working, Rachel?
Oh, I'm not.
Judge, you're muted.
Yeah.
Okay.
All right, this is case number 23 CR 85, State of Ohio versus, where'd she go? There she is, Catherine Leaf. You're Catherine Leaf, preparing there from the counseling center? All right.
Yeah.
This is a pretrial being conducted by Zoom. Ms. Leaf's attorney is Catherine Hapner. She's appearing from her office, appearing from the prosecutor's office, as Prosecutor Attorney Collins. Defendant is charged with aggravated possession of a fentanyl-related compound. This is a first pretrial, I believe. Actually, it's the final pretrial, and the trial date is set for July 25. Now, discovery looks like it's complete to bill of particulars. So where do we stand on this case, Ms. Hapner?
Your Honor, I believe that we've got this case resolved. I need to get the form to Ms. Leaf.
Okay. You have an email there you can send that to her case manager?
I don't. I was going to get that from Ms. Sturgill.
Okay. Who's your case manager, Ms. Leaf?
Felicia, but I've been seeing Annette this week because Felicia is not in for the rest of the week, so.
All right. Annette?
Rachel said she can give you, Rachel said I can give you hers.
Okay.
She's writing it down. All right, so it is rjarrett@counselingcenter.org.
Is it
RJA?
Yeah, RJARRETT.
Okay. At Counseling Center?
Yeah.
at the counseling center, isn't it?
Yeah, at thecounselingcenter.org.
Okay. All right. All right. Well, if you can get, as soon as you get a chance to take a look at that, Ms. Leith, and you can get in touch with your attorney to discuss that. And if there is an agreement, we will be able to do the plea at least by Zoom, and you won't have to come back here. So, Ms. Hammond, if you can get that done now, the deadline is actually Monday, but if you have some time Tuesday, we can go ahead and set this for a plea.
Yeah, we're doing Robert Taylor at 1:30. Do you want to do it at that time or soon after that?
Yeah, we're pretty booked up, but I can probably work it in. Well, let's see. Now, I got to be out of here by 3:15. I have an appointment. Is a grand jury just meeting half a day, Miss Collins? You're muted.
It should be, Judge, but we do have some pretty big cases to go this time. We don't have a lot of cases, but some of them are big.
Are you, well, are you planning on using the courtroom?
Yes.
Okay. Well, then we wouldn't be able to do anything in the morning.
Plus, it's a new grand jury, and that always makes me nervous. They take a little longer.
Oh, yeah, that's true. They usually do. Yeah. Let's see, I have 3 sealings at 1:30, but I went ahead and set another hearing that time with that understanding. Let's see, final pretrial. Yeah. What about the 12th?
No, I'm in trial in Fayette County that day.
All day?
Yeah.
Okay, what about Thursday? 13th.
I've got a 9 o'clock in common pleas in Fayette. I'm in Washington Courthouse Community from 9 till noon, although I could get on and do it by Zoom in that time period.
Or how about in the afternoon?
I've got a 1:30, a 2, and a 2:30 in Fayette Juveniles.
Okay, so we can just do a Zoom from, what time did you say would be best for you?
I can either do it in the morning between 9 and noon or at 1 o'clock, either one.
All right, let's do 10 a.m.
Okay.
Plea hearing. All right, so we will send a link there to, the counseling center for you, Miss Leaf, and your attorney's going to be
Okay.
sending you the information. Then you need to make sure you get back with her if you have any questions and discuss it with her. And then if you're in agreement with it, sign it and send it back to her so that she can get the prosecutor's office to sign and get it to court for the hearing.
Okay.
All right, anything further in this case, counsel?
No, Your Honor.
All right, thank you. All right, Mr. Arjima, Ms. McKenzie showed up. CR 80, State of Ohio versus Taylor Deitch. And your Taylor Deitch appearing there on the screen marked Judy Shelton.
Yes, sir.
All right. This is a hearing being conducted by Zoom. Ms. Deitch's attorney is Dennis Kirk, appearing from his office. Appearing on behalf of the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged with aggravated possession of methamphetamine, a third-degree felony. This is a final pretrial, I believe, and the trial is set for July 27th. Now, I have received a plea of guilty form, Ms. Deitch, which indicates that you are going to enter a plea of guilty. On page 1, there's a caption with your name and the case number and a plea of guilty, and I'm going to hold that up to my camera and ask you if you recognize that form there.
Yes, sir.
On page 3, there is a sentence that reads that about a third of the way down, a quarter of the way down, I enter this plea voluntarily. Right below that is signature defendant and appears to be Taylor Deitch. Is that your signature there?
Yes, sir.
When did you sign this, Miss Deitch?
Did you say when?
Yes.
About a week and a half ago.
All right. And were you there at the counseling or at the treatment center when you signed it?
Yes, sir.
All right. And had you talked with your attorney about this before you signed it?
Yes.
And he answered any questions you had and explained what would be in it for you?
Yes.
Do you feel you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And are you still wanting to do it today?
Yes, Your Honor.
All right. And you entered into this agreement to plead guilty and are entering your plea today voluntarily?
Yes.
All right. Now, the agreement states that you are going to withdraw your not guilty plea, plead guilty to the charge in the indictment of aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code, third-degree felony. It further states you understand the maximum penalty for that could be 36 months and the minimum be 9 months, and there are certain levels in between those two ranges. There's also a fine available of up to $10,000 and a possible license suspension of 6 months to 5 years. In this case, a prison term is presumed to be necessary but is not mandated. Do you understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control for a felony in this state?
Yes, I'm on probation in Claremont County.
All right, and what is that for?
An F5 aggravated possession.
All right, if you should be sentenced to prison in this case, if convicted, and if you should have your probation revoked in Claremont County because of this conviction and sent to prison, those sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes, Your Honor.
Now, under the law, if you are sentenced to prison and serve a prison term on this offense, once you complete that prison term, it is possible that the Adult Parole Authority would exercise the option that's granted to them under the law to put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under the terms that are set by the APA by a parole officer. And if they determine that you have not complied, they could return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum or cap of half of your prison term for all violations. But should you be convicted of a new felony under post-release control, then in addition to whatever sentence the judge in that new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time's left on this that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively sentenced to the new case. Do you understand that?
Yes, sir.
Now, this is not a mandatory prison offense under the law. The court could impose, instead of a prison term, what's called community control or probation. That could be mean that you would be under supervision of the probation department of this county for a period of up to 5 years under the term set by the court. If during that period of time the probation department felt that you were not in compliance, they would file a written notice of that with the court, provide you a copy. There would be a hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 36 months and fine you $10,000. Do you understand that?
Yes, sir.
All right. Now, the charge in this case alleges that on or about December 5, 2022 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in amount equal to or exceeding bulk amount but less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code. So that is the charge, the third-degree felony with the penalties I've just explained. Now, do you understand what it is you've been accused of by the state, what they said you did, when, where, and how they alleged that you did it?
Yes, sir.
And have you discussed the nature of the charge, possible evidence in the case, possible legal issues in the case, and possible defense you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone promised you anything to get, has anyone threatened you in any way to get you to plead guilty?
No, sir.
Now, on page 2, there are a couple of lines that are printed in bold and underlined, and they have been, part of that has been stricken out to show that it's not applicable, and then there's been some additional writing inserted. And initials DK, which indicates Mr. Kirk did that. And so I'll read that as it's been changed. Defendant shall enter plea of guilty to the indictment. State defense will argue sentence. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
All right. Now, do you hold any type of license or certification from any state governmental agency that regulates any occupation or profession in the state?
No, sir.
All right. Now, you have certain constitutional rights you must understand before I can accept a plea from you. First, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'd be instructed on the law by the judge, and then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up in writing the right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury, it would be the judge would hear the evidence, the judge would apply the law, the judge would be the one that would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have to confront the witnesses against you at open court and to have your attorney cross-examine those witnesses. So what that means is that witnesses against you have to come into the courtroom, testify in public session in front of you and your attorney and anyone else may be present. After the prosecutor's done asking questions of the witnesses, your attorney has the right to ask questions, which is called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court and testify on your behalf, the same as the state. So if you have witnesses you're uncertain would come in voluntarily, at your request, the court issues a court order, it's called a subpoena, that would force those people to come to court to be able to testify if you wanted them to, though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence or to testify in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
All right, now under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. by being indicted. In fact, under the law, you don't have to present any evidence at all in your own defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on each essential element of the offense charge by proof beyond a reasonable doubt, which is on every essential element of the offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Are you now originally entered a plea of not guilty? Not guilty plea denied the allegation, and the indictment denied you committed any crime and exercised or revoked all the rights I've just described. If you change your plea from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, that you committed that crime. And that plea waives or gives up all of the rights that I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives or gives up your right to a jury or court trial. Waives or gives up your right to confront the witness against you and to cross-examine them through your attorney. It waives or gives up your right to compel witnesses to come into court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. It waives or gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also waives or gives up any right to file an appeal you feel you may have had up until this point in the case. If I should sentence you to the maximum sentence, or under other certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. And finally, it waives, gives, or does subject you to being sentenced immediately by the court. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Deitch?
Yes.
Right. Now, do you have any questions about the charge, the possible penalties?
No, sir.
You understand them?
Yes.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter it here today?
Nope.
You understand that?
Yes.
You have any questions about the plea of, or I'm sorry, the constitutional rights I've explained?
No, sir.
You understand it? Them?
Yes, sir.
And you understand the plea agreement?
Yes, sir.
Now, I didn't say this at the beginning, but if you need to speak with your attorney, we can set the two of you up to be a breakout room with just the two of you there being able to talk, no one else being able to see you here. Do you understand that?
Yes, sir.
Do you have any need to talk with him at all?
No, sir.
Okay. And I believe, I don't believe I said this at the beginning of the hearing, but Mr. Kirk, you and your client are both agreeable to this matter being conducted by Zoom today rather than Ms. Deitch having to come before the court personally to appear?
Yes, Your Honor.
And you're in agreement with that, Ms. Deitch?
Yes, sir.
All right, thank you. All right, do you have any questions about anything that we've talked about here this afternoon?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of the plea agreement?
Yes, sir.
All right, then as to the charge which alleges that on or about December 5, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.11 of the Ohio Revised Code. Charge of aggravated possession of methamphetamine, a third-degree felony carrying a possible prison term between 9 and 36 months, and a fine of $10,000 and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, thank you. All right, the court will find that on this day in open court, defendants advised of all their constitutional rights made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Pleas accepted and ordered filed. Defense found guilty of the charge as set forth in the indictment. This matter will be set for a sentencing hearing. August the 2nd at 9 o'clock. Bond will be continued. The sentencing will be in person. Mr. Fulton will be in touch with you there. You need a phone number there to contact her, Mr. Fulton?
I can get that from Ms. Sergio, I believe.
Okay. All right. Thank you. All right. Is there anything further from counsel, Lynn?
No, Your Honor.
All right.
Your Honor.
August the 2nd, then, in person here at the courthouse, Ms. Deitch. Thank you.
Thank you, sir.
All right. 23 CR 116, State of Ohio versus Donna McKenzie. Ms. McKenzie is appearing from the probation department. Her attorney is Dennis Kirk, appearing from his office, and appearing from the prosecutor's office of prosecuting attorney Collins. The defendant is charged along with 2 co-defendants. It looks like she's charged in count 11 only, permitting drug abuse, a 5th-degree felony. This is a first pretrial. Final pretrial is August the 2nd, and trial date is set for August the 28th. Now, I see that discovery was provided to the defendant. You received that, Mr. Kirk?
I have received it, yes.
All right, your discovery will be due by the final pretrial on August the 2nd. And do you anticipate any pretrial motions?
Not at this time.
All right, if you do, they'll be due by the same date. And has there been a written plea offer provided?
There has.
All right, is your client aware of it?
She is not yet, but I'll be making her aware of it.
All right, and you have a number for her to contact to talk to her to get her in for your appointment?
I do.
All right. All right, on the other matters that need to come up at this time?
No, Your Honor.
Let's stay.
All right, from your next pretrial then, Ms. McKenzie, go to the probation department just like you have today. All right?
Okay, thank you.
Thank you. All right, Andrew John. All right, Braley. All right, you're James Braley, James Eric Braley, appearing there from the probation department?
Yes.
All right, we're getting somebody coming in from the counseling center. All right, this is State versus James Eric Braley, case number 23 CR 118. Mr. Braley is appearing by Zoom from the jail, or I'm sorry, from the probation department. His attorney is Sarah Barger, appearing from her office. Appearing on behalf of the state is prosecuting attorney Collins. Defendant is charged along with a co-defendant in a 5-count indictment. This is a first pretrial. First pretrial. Final pretrial is on the 19th, and the trial is set on August the 7th. Now, let's see here. See, the state provided the bill of particulars on the 30th of June, and also has provided discovery. And have you provided discovery yet, Ms. Barger?
Not yet, Your Honor.
All right, it'll be due by the final pretrial. Are you anticipating any pretrial motions?
Not at this time.
Okay. And if there are any, they're due by final pretrial. Has there written plea agreement been provided?
Yes, Your Honor.
All right. Is your client aware of that?
Not yet, Your Honor.
All right. All right. You do have his contact information.
I do not. I need his telephone number.
All right. You want to provide a number, Mr. Braley, so Ms. Barker can get in touch with you to schedule an appointment.
Yeah, do you want me to go ahead and give it to you now?
Yep, we got you. Go ahead. Yep. Well, we've had a breakdown on our end. Everybody's froze. Can you see anything going on there? All right.
Progress.
Are we zooming now? Okay, all right. Sorry about that. We lost the internet here. So I don't know how I got you all back without logging back in, but you're there. All right, did you get the number to Miss Barger?
Yes. I did. I got it from him, Your Honor.
All right,
We're good.
All right, good. All right. Then we'll do your next pretrial by Zoom as well. Just report to probation department then, Mr. Braley. Thank you.
Okay.
All right. Now, we have Mr. Johnson. State of Ohio versus Andrew Johnson. And you're Andrew Johnson appearing there on the screen that's marked Samsung SM590-8U, I think is what it is. That's you.
Yes, sir, Your Honor. Can you hear me?
Yes, I can. All right.
Okay, great.
All right. This is a pretrial being conducted by Zoom. Mr. Johnson's appearing on this phone. His attorney is Catherine Hapner, appearing from her office. Appearing from the prosecutor's office is Annika Collins. The defendant is charged with aggravated trafficking, aggravated possession of fentanyl-related compound. This is a final pre-trial. Well, actually, this is a status conference because the trial was set for the 10th of July. Ms. Hapner filed a motion last week to vacate that date to have a status today, anticipating that we might have a plea, as I understand it. So, Mrs. Hapner, you want to bring us up to date on the record?
Yes, I did talk with Mr. Johnson pretty much at length on Friday, and he indicated to me that he was going to accept the plea offer. I did send the plea form to him. I simply have not received it back yet.
Did you get that, Mr. Johnson?
Yes, sir, Your Honor. I was able to finally go to the library, scan it, because I had to use my actual signature. It had marked that it had been, it's processing or buffering, I'm not real tech savvy, but I did sign it, and it maybe is marked in, Catherine, if you can maybe check your spam.
All right.
When did you send that back?
Well, the first attempt was yesterday, and then just not even 5, maybe 10, 15 minutes ago, I was in the process of figuring out this, the ID number and everything.
I don't have, do you know what email you sent it to?
Let's see.
You hear that, Mr. Johnson?
Yes, sir, Your Honor. That's what I'm going through, the one that she had,
Because you don't send it back to me, to the email that I sent it from. I sent it from my scanner. Which only sends.
Then that's the, then that's what it is then.
Okay, because it needs to be sent to khafner@hafnerlaw.com.
Okay. K. Hafner. Just the K?
Yeah, just the letter K, HAPNER@HAPNERLAW.com.
Yeah, okay, you're moving too fast for me. Catherine Hapner at ATT.
No, at HAPNERLAW.com, hapnerlaw.com.
So it's khapner@hapnerlaw.com.
Yep.
Okay, I'm not sure if I can do that as we're on the meeting. I can try. It might disconnect this, or I can have it for sure, because that's
send it back by tomorrow noon.
Okay, Rocky.
Now,
Your Honor.
Yeah, okay.
Your Honor.
Your Honor.
Have they drug tested you yet down there?
I
think they maybe ought to do that pretty soon. Because I don't think you're in, you're under the influence, I can tell. So, all right. Now, Mr. Johnson, you need to be keeping in contact with your attorney and the probation department because they didn't know you were down there. I know they had arrangements for you a week before and you didn't show up. But, we need to get this matter resolved. So if we don't have that plea back form by tomorrow, I'm going to set this for an in-person hearing, and you're going to get yourself up here. If you get that back to her tomorrow and she can get it to the prosecutor, then we'll go ahead and set. But I'm going to set a hearing right now, and we're going to do it in person unless you get that stuff back to her immediately. So let's see, I'm trying to remember earlier today we went through several hearings, dates. Miss Hapner, next week, I know I'm out Monday for a funeral. And I know Tuesday is really busy. So did you have any time Thursday or Friday? The 14th, 13th or 14th?
Not Friday afternoon, but I've got any time except between 10 and 11 on Friday morning.
Any time except what?
Except 10. I'm not available between 10 and 11 on Friday.
All right, let's do it at Friday at 9 o'clock then, July 14th at 9 a.m. if you get that back to her, Mr. Johnson, by tomorrow, so we can get a link out to you, that will be by Zoom. But if she doesn't get it, we're not gonna sit around and wait for you to figure it out. You just have to bring yourself up here, and there'll be another form waiting on you up here at 9 a.m. on Friday morning, next Friday. You got it?
Yes, sir, Your Honor.
All right.
And just to be clear, that's Friday the 14th, correct?
Correct. Friday the 14th, a week from Friday, from this coming Friday. Yeah, the 14th of July. All right.
And that is .com, right, Catherine?
Yes.
Okay.
All right, thank you. You can go ahead and sign out. All right, that's everybody then we have, I think, on the docket. All righty. Thank you, everyone.
You should